She decided to bind his arms and legs, treated like he was a piece of garbage. Mother chokes him and wants to kill him.
I hate you and I hope you die in your. Get up, bro. Come here, bro. Go that. Stay up. Hey,
In 2022, Trenjavius Hutton was fatally shot during an incident at Town East Mall in Wichita, Kansas. The person responsible, Tabrius Robinson, was arrested and charged with second-degree murder, attempted second-degree murder, and aggravated battery. In 2024, Robinson pleaded no contest to the charges. His sentencing hearing took place in 2025, where family members of both the victim and the defendant gathered in court to hear the outcome. During the hearing, Hutton's mother delivered an emotional statement, asking the judge to give Robinson the maximum sentence, expressing her grief and frustration.
I'm not saying that we innocent, but you know what I'm saying? I hate him, and I hope something bad happens to him in jail. I hate it. And I think that you should consider, you should give him the max that you can, because evidently he don't care.
I hate you and I hope you die in your.
Her remarks led to tension between the two families, which briefly escalated into a physical confrontation inside the courtroom.
Judge was asking how you guys go. Nobody.
Get up, bro. Come here, bro.
Go that.
Stay up. Yeah, you was a.
Come on, guys.
Deputies quickly intervened to restore order. After the situation was brought under control, Robinson was sentenced to 21 years in prison. Following the incident, 6 individuals involved in the courtroom disturbance were charged with misdemeanors related to disorderly conduct, and a protective order was issued to prevent further conflicts during future proceedings. In April 2020, Roger Harris was pulled over in Fresno after running a stop sign. During the stop, officers noticed a weapon in his vehicle, which he was prohibited from possessing due to prior felony convictions. Realizing the officers had seen the weapon, Harris suddenly fled the scene, leading police on a high-speed chase. As he sped through intersections, Harris collided head-on with a truck driven by 48-year-old Guy Shearer, him instantly. After the crash, Harris attempted to escape on foot but was quickly apprehended. Authorities later confirmed Harris was under the influence of drugs at the time of the crash. Following his arrest, Harris faced multiple charges, including DUI vehicular manslaughter, fleeing police causing death, and illegal firearm possession. More than 5 years after the fatal crash, Harris appeared in court and accepted a plea deal, which resulted in several charges being dropped while he pled guilty to the most serious offenses. During the sentencing hearing, Shearer's wife and son delivered emotional statements about their ongoing pain and the irreplaceable role Shearer held in their lives.
My heart was ripped from my chest on that day, and I know I will never be the same. And I know my children will never be the same. The kids need Guy more now than ever. I need Guy more now than ever. Guy's parents need him now more than ever.
Birthday, no Merry Christmases, no Happy Father's Days spoken between me and my father again. I will never see him get to hold his grandchildren. I'll never get to ask my dad for help. I lost my hero.
Harris, with his head lowered, apologized directly to the family, acknowledging the irreversible harm he had caused.
I'm so sorry to Jacob and to Mr. Shearer's wife and Jacob's brother. I watched your interview on the news, Jacob, but I'm sorry.
Even if he's released from prison, he will ever be able to regain his eyesight.
His defense argued that his deteriorating eyesight would make him unlikely to commit future violent crimes. Ultimately, Harris was sentenced to 35 years to life in prison, along with required substance abuse treatment. In the early morning hours of April 5, 2025, 28-year-old real estate agent Ashley Long, visiting Dallas from Southeast Texas, was walking along Main Street in downtown with her friend, 36-year-old William Kistler. As they strolled, Kistler's hand brushed against a passing Mercedes, prompting the vehicle to stop almost immediately. Surveillance footage later showed Kistler attempting to retrieve a weapon from Long's purse, while 34-year-old Kendrick Finch stepped out of the Mercedes already holding a weapon. According to the lead homicide detective, Finch's weapon was aimed at Long and Kistler before Kistler managed to point his own weapon, indicating that Finch likely fired first.
He was the first one to step out with it.
I can tell you Mr. Finch's gun was pointed in Mr. Kistler and Miss Long's direction, and she had started to fall prior to what appears to be Mr. Kistler directing his gun at Mr. Finch. So to go out on an assumption, I would assume that Mr. Finch fired first.
Shots were fired and Long was struck, later dying from her injuries, while Kistler survived. Following the shooting, Finch initially contacted police the next day, but did not immediately surrender, resulting in an arrest warrant. He turned himself in on April 18th. During a bond reduction hearing in May, Finch's defense argued he had acted in self-defense, stating Kistler's movement toward him with a weapon left Finch no choice but to fire.
He's fighting around trying to get that gun, and finally gets it, goes like this towards my client. And when he takes those steps towards my client has every right under the law to defend himself.
The prosecution, however, maintained that Finch posed a danger to the public, pointing out that he fired at least 8 shots in a crowded commercial area filled with pedestrians and traffic.
He fired that at least 8 times in a crowded residential commercial street with cars and people walking all around.
The writ is denied. The bond remains at $500,000.
After reviewing the evidence, the judge denied the defense's request to lower Finch's $500,000 bond, emphasizing the serious nature of the charges. Finch later posted bond and was released, while Long's family continues to push for bail reform in Texas as the case moves toward trial. In April 2025, a family dispute unfolded on Sussex Street in Detroit just a day after the family had lost their matriarch. What began as a heated argument between 2 brothers in their 50s quickly escalated, drawing in several other relatives. Tensions rose further, and during the physical confrontation, a weapon became involved. In the chaos that followed, 5 family members were injured, including Kara Langdon, who was struck, resulting in severe injuries.
I was shot by Nicole A. Langdon. I was shot in my right shoulder a couple times, 2 times according to the doctor. I had an examination and I have a broken shoulder.
According to Kara's testimony, her aunt, Nicole Langdon, was one of the individuals who fired a weapon, while her father, Kevin, attempted to intervene and restrain Nicole. At the same time, Larry Langdon reportedly became involved.
The only thing I remember is the shot where I was shot, and then it was radio silence in my right ear. When Nicole A. Langdon ran up, my father, he ran to restrain her, not fight her, and as he held her, Larry Langdon ran behind my father, Kevin Langdon, and put him in a chokehold, and they both had firearms at that point, Larry Langdon and also Nicole Langdon.
Following the incident, Nicole Langdon was arrested and charged with several offenses, including assault with intent to murder. During her preliminary hearing in May 2025, the court reviewed video evidence and heard testimony detailing the sequence of events. The defense argued that the charges were excessive, emphasizing the emotional and chaotic nature of the family dispute.
When you fought 1604-21, you've been shot at this point, right?
Yes, correct.
Did you have an opportunity to see any shots that occurred after you were shot?
No.
Did not. Okay.
Despite this, the judge determined there was enough evidence for the case to move forward. Nicole's next court appearance was scheduled as the legal process continued. In June 2022, Detroit police, responding to a welfare check at a home on Monte Vista Street, discovered the body of Chase Allen hidden inside a freezer. An investigation revealed that Chase had died from injuries. His mother, Azurity France, was arrested and charged. Further details emerged that some of Chase's siblings had witnessed parts of the incident.
2 of the siblings of Chase Allen witnessed Miss France putting their deceased brother in a freezer. One of the children, who was 9 years old at the time, at Miss France's direction, went and got the laundry bag that she eventually put him in.
Authorities also revealed that Child Protective Services had previously received several complaints and conducted multiple investigations into the household, but failed to intervene effectively.
He was failed by so many during his short life. CPS. There was at least 7 rejected complaints by CPS, as well as at least 6 CPS investigations.
The one thing we can agree upon is this child was failed from every single adult that could have helped him.
In July 2024, Azurity France pleaded guilty to second-degree murder, and all other charges were dismissed as part of a plea agreement. During sentencing, her sister read a victim impact statement expressing hope that France would one day feel remorse for her actions.
I pray that you find healing, that you actually one day regret what you did to your children, especially Chase.
The judge sentenced France to 35 to 60 years in prison and ordered her to receive mental health treatment while incarcerated. Meanwhile, Chase's 4 siblings were placed in foster care, where they are receiving ongoing therapy. In 2025, Chase's father filed a lawsuit against Child Protective Services, alleging that repeated failures to act on reports of abuse contributed to the tragedy. In May 2024, a confrontation at Stein Park on Detroit's west side escalated into a serious incident. The dispute began as an argument between 2 young women, one of whom contacted her brother, Alvin Noble, for assistance. Noble arrived at the park carrying a firearm. After a brief exchange, shots were fired, leaving 4 people injured. The victims included a boy, a girl, a pregnant 18-year-old woman, and another 18-year-old woman.
This was a totally vicious, uncalled for, and unhinged attack on the community members in that park that night. One struck a 6-year-old child nearby, a 6-year-old child nearby, a pregnant 18-year-old woman was struck, and another 18-year-old woman was struck in the face.
Fortunately, all the victims survived and were expected to recover. Prosecutors later emphasized that 3 of the victims were innocent bystanders who had no connection to the initial dispute.
At the time of his arrest, the defendant was seen leaving his house with a duffel bag and a packed backpack. And further, the defendant, who is 17 years old, did admit to unlawfully possessing a firearm for at least 2 years.
I'm totally upset about every last bit of it. Young men, do not accept a phone call like this. If they can't call you over to when they got their paycheck, don't get called over to a beef. They don't call you over when they're going shopping or when they're going to get a new car. They got a new job lead or a new business. They're calling you over to come over here and slide for the beef and leaving you now in the world of trouble.
Following the incident, Noble was arrested and faced multiple charges, including 4 counts of assault with intent to murder, several weapons offenses, and multiple felony firearm charges. At his arraignment, Noble's bond was set at $500,000, and additional conditions such as house arrest and electronic monitoring were outlined if bond was posted.
I wanted the community to know that no one else is at risk. When you get a quadruple shooting, you get a lot of calls and people saying, what's going on with the arrest? Is anybody in custody?
Community leaders expressed concern about how quickly conflicts among youth can escalate when weapons are involved, urging young people to avoid being drawn into dangerous situations. Court proceedings are ongoing as the legal process continues. In March 2024, Lila Cassell was found unresponsive inside her home in Wayne County, Michigan. According to investigators, Lila sustained serious head injuries on March 13th, but no one contacted emergency services until March 16th. By the time help arrived, Lila could not be revived. An autopsy later determined that she passed away due to severe injuries that led to significant swelling.
The sheer brutality that innocent year-old Lila suffered on March 13th of 2024 is really like nothing I've ever seen in my 5 years of handling child cases. The massive amount of swelling to her head and her face, she was completely unrecognizable. The cause of death, massive blunt force trauma to the head and face, which ultimately caused excessive brain swelling. She could have been saved. Lila was just placed in a bed. Her mother went out to the store to get diapers because this child could not go to the bathroom. Diapers, heating pads, Vaseline, as well as some liquor for herself, while her daughter is laying in bed dying, a slow death.
During the investigation, Lila's mother, 30-year-old Chelsea Renee Duperron, initially claimed her daughter had fallen down the stairs. However, as authorities questioned her further, Duperron shifted her explanation, mentioning spirits and claiming supernatural influences were involved.
She mumbled out loud, "Well, I swear to God, this is not me. This sounds crazy, but there's bad spirits." Duperron stated there was a lady and she came out of nowhere. Duperron told him a story about a spirit causing her to do that to the victim. Duperron told him a spirit or ghost was causing the victim to act crazy. Duperron was talking about how she was possessed.
Further details revealed that in the days following the injury, Duperron left the house to purchase various items while Lila remained in critical condition. Neighbors later shared that while they never directly witnessed physical abuse, they often heard yelling from the home and had expressed concerns to authorities in the past. Duperron was arrested and charged with felony murder and first-degree child abuse. She pleaded not guilty during her arraignment and is currently being held without bond as the case moves forward through the court system. In early May 2025, Jagat Singh, already on probation for a prior DUI conviction from 2023, was involved in a deadly crash in East Central Fresno. Singh was driving a stolen Range Rover under the influence when he collided with a car carrying 3 boys. 18-year-old Maddox Green died at the scene, while his best friend, 19-year-old Jordan Galves, succumbed to his injuries at the hospital the next day. A third boy was rescued from the burning vehicle by bystanders. After the crash, Singh fled on foot but was soon located by police. During questioning, he admitted to being the driver and acknowledged that he was aware of the dangers of drinking and driving. His blood alcohol level was found to be more than twice the legal limit. Shortly after the incident, Singh faced multiple felony charges, including 2 counts of murder.
Third was rescued from the burning vehicle by bystanders. Following the collision, as opposed to rendering aid to assist any of the 3 occupants out of the vehicle, the defendant chose to flee on foot.
During an initial court appearance, the judge denied him bail, a decision that was met with relief and applause from the victims' families, who saw it as a first step toward justice.
No bail at this time.
Emotional vigils were held at the crash site as family and friends gathered to honor Maddox and Jordan.
It's definitely challenging. I lean a lot on my faith to help me get through this. I mentioned earlier, I've already forgiven this individual, so it's more about just justice for my son, Jordan, and for Maddox. It's overwhelming. We're still getting, people are reaching out to me, even students are reaching out to me saying, we didn't know that was, Jordan was your son, and he's such a good man, such a good kid, so yeah, it's overwhelming. They had a big impact on a lot of people.
Maddox's family found out that he feared that he would die by fire.
In his writings, we've come to find out that, his fear was of himself and his family members perishing in a fire. But it turns out, unfortunately, I guess he knew something that we didn't.
Both families expressed their determination to attend every court proceeding, seeking full accountability for the tragic loss of their loved ones. Singh pleaded not guilty to the charges, and further court hearings are scheduled as the legal process continues. On March 24, 2013, 53-year-old Elisa Sherman arrived at her attorney Gregory Moore's downtown Cleveland office for a scheduled meeting regarding her divorce. According to investigators, Moore had lured her there under false pretenses to prevent her from attending an upcoming court hearing. Shortly after arriving, Sherman was attacked outside the office and later passed away from her injuries. To cover his tracks, Moore used several calculated steps to mislead investigators. He swiped his office ID badge to make it appear as though he was inside the building, but secretly entered through a rear entrance. Additionally, he disconnected his phone from the mobile network and used a mobile hotspot, making it difficult to trace his location at the time. These tactics complicated the investigation for years, as law enforcement lacked the technology at the time to detect such subtle digital manipulation. It wasn't until 2021 that the Ohio Bureau of Criminal Investigation, under Attorney General Dave Yost, reopened the case using advanced forensic tools. New technology allowed investigators to uncover anomalies in Moore's data, including inconsistencies measured in seconds, destruction of evidence, and manipulated digital records that pointed to his involvement.
Or anomalies measured in seconds. There was a destruction of evidence that all pointed toward what actually happened.
After more than a decade of investigation, a grand jury indicted Moore in 2025 on multiple charges, including murder and conspiracy. He was located in Texas, arrested, and later extradited to Ohio, where he pleaded not guilty during his arraignment. Bail was set at $2 million as the case now moves forward to trial. Brandy Catrice Pierce had a long and troubled history with Child Protective Services before the death of her elder son, Zamar King. Over the years, officials received multiple reports, including concerns about neglect and endangerment. In April 2024, Pierce brought her 2 sons to a hospital in Detroit. During that visit, Zamar confided in CPL, saying his mother hurt him and made disturbing threats. However, after a brief investigation that confirmed the family had food, water, and electricity, the case was closed without further action. In October 2024, Pierce was living on Woodingham Drive in Detroit. Records show she purchased a shovel and wagon online. On the morning of October 24th, Zamar woke up early, as he usually did. Authorities allege that sometime that morning, Pierce caused him serious harm, then used the wagon to move him to the backyard where she had dug a hole. There, she concealed what had happened by covering the area. Soon after, she left Detroit with her younger son, traveling through Illinois and Wisconsin before settling temporarily in Georgia. On December 20th, 2024, police in Brookhaven, Georgia were alerted when Pierce's younger son was found in distressing conditions inside a vehicle. That discovery led to renewed interest in her situation, and authorities contacted Detroit police. On January 6, 2025, the landlord of Pierce's former Detroit home found what appeared to be human remains behind the garage. The discovery led investigators to uncover Zamar's body. A medical examination confirmed the cause of death, and a nationwide warrant was issued for Pierce's arrest.
Yes, Judge. People are asking for a remand in this case. The facts in this case are nothing short of egregious. Zamar King was a 9-year-old child who was treated like he was a piece of garbage. He deserved better, and we believe the evidence will show that back in April of 2024, the defendant and her 2 children went to a hospital for help. CPS got involved. Zamar told CPS that his mother trusts him and wants to kill him. Fast forwarding to October of 2024, the defendant and her 2 children are living in Detroit on Woodingham. The defendant orders a shovel and a wagon from Walmart. She digs a hole in her backyard behind her garage. Later in October, I believe October 24th, Zamar wakes up early as would be usual for him. We believe that the evidence will show that the defendant smothered and suffocated Zamar, and that the defendant heard his last gasping breath and decided to walk away. That when the defendant came back to Zamar, he was blue. And instead of helping him, she decided to bind his arms and legs, put him in a wagon, and take him out to the hole that she had in her backyard and bury him.
On January 10th, Pierce was taken into custody in Georgia and later extradited to Michigan. She was officially charged on February 5th with multiple offenses, including murder, child abuse, evidence tampering, and concealment of a death. Prosecutor Kim Worthy described the case as deeply disturbing and tragic.
So I want to talk about a case of a young boy named Zamar King III. The alleged facts in this case are that we are announcing today. On January 6th of 2025, the Detroit Police Department was notified and summoned to a house on Woodingham in Detroit. They had been contacted by the landlord that owned that house. When he went to that house, the landlord contacted him when he went to that house to prepare it for a new tenant. That he called the police because he found a shallow grave in the backyard of the home on Woodingham. Upon arrival, the police were shown that grave where a human foot was sticking out of the ground. The foot was believed to belonged to a small child. After an extensive investigation by quite a few agencies, and the chief will talk about that in a minute, the buried body was discovered to be 9-year-old Zamar King III. That the mother of young Zamar was 41-year-old Brandy Pierce. It's alleged that she killed him, and that the cause of death found by the medical examiner was smothering and neck compression. So I want to just further go ahead and tell you what other facts about this case. It's alleged that she purchased a shovel. She bound him by tying his hands and feet together and dug a hole in the background of the house on Whittingham, where she had been living for a short time. She then put him in this hole and covered him with dirt. That after killing her son, she and her other son, who was 3 years old, moved to Georgia, Cobb County to be exact. It was determined that this, in fact, happened sometime in October of 2024. That Zamar's mother, Brandy Pierce, is currently in Cobb County, Georgia, and we will be requesting her to be extradited back to Michigan. We are charging Brandy Catrice Pierce today with 1 count of murder in the first degree premeditation, which carries a life without parole sentence, mandatory. Count 2 is homicide felony murder. Again, the mandatory penalty is life in prison without the possibility of parole. Our 3rd count is child abuse in the first degree, life or any term of years in prison. The first degree child abuse is the felony to make out the felony murder we are alleging. Count 4 is tampering with evidence, criminal case punishable by more than 10 years in prison. And the 5th one is interfering with, concealing and interfering with the death of an individual. 4 years, of course, that being 9-year-old Zamar King. As always, this defendant is presumed innocent unless or until proven guilty. I should tell you that Judge Aaliyah Sabri of the 36th District Court authorized these charges yesterday. And since we will be requesting extradition, we will notify you all when in fact she is back in the state of Michigan. So of course there is no next day for court. Again, let me just repeat, these charges and allegations are quite serious. They're deadly, they're shocking, every platitude that you can think of, but again, Ms. Pierce is still presumed to be innocent unless or until proven guilty.
During her arraignment on February 27th, Pierce stood mute, and a not guilty plea was entered by the court. Prosecutors strongly opposed her release, citing both the severity of the allegations and the fact that she had left the state. Her defense attorney argued for release under GPS monitoring, suggesting she stay at a homeless shelter while awaiting trial.
The callousness with which the defendant treated Zamar cannot be understated. The defendant is an absolute danger to the community and a flight risk. After the killing, the defendant took herself and her other son, Illinois, Wisconsin, and then down to Georgia, where they had been residing. The defendant was subsequently arrested 2 times in Georgia for crimes involving her other son and drugs. We had to extradite her back on this warrant. So people believe it's appropriate.
Okay, thank you. Your response, Mr. Murray.
Judge, so on behalf of Ms. Pierce, I can tell you that she's 46 years old. She's not employed at this time, Your Honor. She has absolutely no income. She does suffer from disorders that I'm not aware if she's received her medication for. I can tell you that in talking to her, we understand that she's received a master's degree as well. Ultimately, Your Honor, I think we lost Ms. Ripley, so there we go. So ultimately, Your Honor, when it comes to bond, I think it's important to know that it's easy to, read off a police report and read the most egregious allegations and then confine somebody to jail. What I'm asking the court to do here is to use the least restrictive means possible and confine her to a homeless shelter. She would ultimately, any concerns that the prosecutor or the court would have would be addressed with a home confinement GPS tether to a homeless shelter. She is homeless, Your Honor. I don't think it's appropriate for me to even argue the facts in this case at this stage. But when it comes to ties to the community or flight risk, I hear what the prosecutor is saying, that she wasn't found in another state. I still think a tether addresses that. So my ultimate request, Your Honor, is to release her on a reasonable bond, confining her to a homeless shelter.
Okay. Thank you. After listening to the arguments of the parties, the court has had an opportunity to review the investigator's report and take into consideration the background information that has been presented by defense counsel. The court certainly is concerned. Not only is Ms. Pierce a danger to the community, but also a flight risk. After these egregious acts or allegations, she left the state was in Illinois, Wisconsin, and then found in Georgia. So a flight risk, that's pretty much clear. As it relates to being a danger, as Ms. Ripley indicated, the facts are just egregious in terms of how this was found, the condition, being tied, body having been decomposed, the prior information that was submitted in terms of the contact with Child Protective Services. And based upon that information, she definitely poses a threat to the community. So the court believes that based upon the information, finds through clear and convincing evidence that she is a danger. Also, that based upon the information that has been set forth in the investigator's report, it appears that the presumption of guilt is high, and the court is going to remand this matter pursuant to MRE 6.106B1I.
The judge denied bond, emphasizing that the circumstances indicated a risk to public safety and concern over whether she would appear for future court dates. Pierce was ordered to remain in custody. A probable cause hearing was set for March 7th via Zoom, and a preliminary examination was scheduled for March 13th. At that hearing, her attorney requested a mental health evaluation to determine her competency to stand trial. The court approved the request, and proceedings were postponed until the evaluation could be completed. Brandon Christopher Reisner and Aaron William Davis had been close friends since high school. They shared church experiences, attended college together, and maintained a bond over the years. On November 11th, 2022, Aaron visited Reisner at his parents' home on Collingwood Drive in Rome, Georgia. That evening, they went out together and later returned to the house, where Aaron spent the night in a guest bedroom. The next morning, when Aaron failed to arrive at his destination, his family grew concerned and contacted authorities. A search led to the discovery of his abandoned vehicle, a Toyota Prius, in a ditch at Heritage Park. As the investigation progressed, attention turned toward Reisner. When officers arrived at the Collingwood residence, they uncovered signs that something serious had occurred. According to investigators, Aaron lost his life inside the home. Reisner then attempted to clean up and remove any trace of what had happened. He purchased supplies from Walmart and tried to sanitize parts of the room. Later, he transported Aaron's body to a wooded area off Tumlin Drive, where he buried him beneath a fallen tree. Efforts were also made to dispose of Aaron's vehicle and other materials linked to the scene.
Between November 11th and 12th of 2022, at his parents' residence off of Collingwood Drive here in Floyd County, Brandon Christopher Reisner did make an assault upon the person of Aaron William Davis with a blade-like object and with the intent to murder and with malice, by stabbing him repeatedly in the head, neck, torso, and extremities, causing disfigurement and ultimately causing Aaron's death. Then, to cover up his crimes, the defendant attempted to dismember the body, and in doing so removed a portion of the small intestines, which was never recovered. Ultimately, he transported Aaron's body to a wooded area off of Tumlin Drive, which is also within Floyd County, and he buried Aaron in an unmarked grave underneath a fallen tree and root bowl. He then went to Walmart and bought cleaning supplies and attempted to clean Aaron's blood off of the mattress, carpet, and rug, as well as Aaron's blood spatter off of the ceiling of an upstairs bedroom at the Collingwood residence. He then took the victim's car, a Toyota Prius worth greater than $5,000 and which belonged to Aaron's father, Randy Davis, and he attempted to submerge it in a creek in Heritage Park here within Floyd County. When officers discovered his dirty laundry, which consisted of some of the attempted laundered bloody sheets, which were in the laundry room of the Collingwood residence, the defendant then ran, disobeying lawful commands from Officer Trace Bethune to stop. Aaron William Davis was 21 years old when he was brutally murdered by the defendant.
Reisner initially fled the area, but ultimately turned himself in. Over time, law enforcement recovered key evidence and pieced together a timeline that matched Reisner's involvement.
So, There's no negotiated sentence to be recommended to the court, Mr. Reisner, so therefore the sentence will be determined by the court. And for the malice murder charge, the alternative for sentencing will be either life or life without parole. Do you understand that?
Yes, sir.
Life without parole is self-explanatory, I think, but a sentence of life itself would make you ineligible for parole for at least 30 years. Do you understand that?
Yes.
And we will set sentencing for a later date, at which time the state will, and your attorney will both have the opportunity to offer argument to the court for either aggravation or mitigation in their position on which of the alternative sentences I should impose. Do you understand that?
Yes.
Has anybody, your attorney, the state attorney, or anyone else made any threats or promises to you to make you plead guilty in this case?
No, sir.
Have you had sufficient time to talk to your attorney, Mr. Heller, and to discuss your case with him?
Yes.
You understand that you are presumed not to be innocent until proven guilty?
Yes.
Do you understand that when you enter a plea of guilty like you're doing now, you waive and give up these rights?
Yes.
How do you plead to these charges, guilty or not guilty?
Guilty.
Have these questions been read and explained to you?
Yes, they have.
And are you satisfied with the services of your attorneys as rendered on your behalf?
Yes.
I find that Mr. Reisner has been fully advised of the charges against him and the maximum punishment for the offenses. I further find that he has fully understood and responded to the questions that I've asked and has freely and voluntarily entered his plea of guilty without undue influence, compulsion, or duress, and without the promise of leniency. I'll accept it. And so that will be entered. And counsel, when do you propose to be prepared to proceed with sentencing?
In June 2024, he chose to plead guilty to multiple charges, including malice murder, aggravated assault, evidence tampering, and concealing a death. The plea was not part of a negotiated deal, meaning the court retained full discretion over sentencing. During the July 18th sentencing, Judge John Niedrak acknowledged the pain endured by both families, especially Aaron's. While noting Reisner's history of mental health struggles, the judge emphasized the planning and attempts to hide the incident.
I want to acknowledge all the family and friends that are present in court to support not only Aaron Davis, but also the defendant, Brandon Reisner. Both of these young men have been loved throughout their lives. And I know all of you are experiencing tremendous pain, including the Reisner family. But the pain of Aaron's family far exceeds that. To have a young son brutally murdered is unfathomable. I hope that your fond and loving memories of Aaron and that your faith will provide you some comfort as your life continues. Having said that, I have considered all of the facts and circumstances of this case and counsel's arguments. And I have come to the conclusion that justice requires that Mr. Reisner be sentenced on count 1 to imprisonment for life without parole. And that's what I'm going to do. And that's based upon the premeditation, the manner of death, and the efforts to cover up all of the acts. On count 2, felony murder, that will be vacated by operation of law. Count 3, to which Mr. Reisner also pled guilty, will be vacated by operation of law. Count 4, the aggravated assault, will be merged into count 1, as will count 5, aggravated assault, and count 6, aggravated battery. Count 7, concealing the death of another, the sentence will be 10 years. Count 8, abandonment of a dead body, there will be a sentence of 3 years. Count 9, theft by taking motor vehicle with a value more than $5,000, the sentence will be 10 years. Count 10, removal of body parts, be a sentence of 12 months. Count 11, tampering with evidence, be a sentence of 10 years. And count 12, obstruction, that's a misdemeanor, the sentence will be 12 months. So the total sentence is life imprisonment without parole. Did you want to add something, Ms. Mayo?
Your Honor, count 11 is a misdemeanor. You had said 10 years.
Count 11,
Yes,
tampering with evidence.
Yes, sir.
Well, I thought I looked that up. Okay. That will be a sentence of 12 months as opposed to 10 years. The sentence speaks for itself. God bless everybody in the courtroom.
Oh, Your Honor, would you include a condition of no contact of any kind with Sarah and Randy Davis and their immediate family, as well as Charlie Girls Challenger?
He's not on probation. The straight sentence is up to the Department of Corrections to control that. That'll conclude this matter. He'd bring the sentence back when it's finished.
Given the circumstances, Reisner was sentenced to life in prison without the possibility of parole, along with additional years for related offenses. The courtroom heard heartfelt statements from family members, and the judge concluded by expressing sympathy to all affected by the tragedy. In January 2021, Victoria Torrey Smith was living in Simpsonville, South Carolina, under the care of her foster parents, Jerry Austin Robinson and Ariel Robinson. On January 14th, emergency responders were called to the home and found Torrey unresponsive. She was transported to the hospital where she was pronounced dead. Medical professionals determined she had suffered fatal internal injuries. Investigators quickly turned their attention to the foster parents. Ariel Robinson, known for winning Season 20 of the Food Network's Worst Cooks in America, was charged with homicide by child abuse. Jerry Robinson, her husband, initially claimed no knowledge of the incident, but later admitted to witnessing Ariel's harsh disciplinary methods. In April 2022, Jerry Robinson pleaded guilty to aiding and abetting homicide by child abuse.
Mr. Robinson, before we go any further, you heard the facts as stated by the solicitor. Is that what happened?
Yes, ma'am.
And how do you plead to this charge? Homicide by aiding and abetting, homicide by child?
Guilty.
All right. I'll accept your plea as being freely and voluntarily made with the advice of extremely competent counsel, with whom you say you're well satisfied. Plea does have a substantial factual basis. I'll remind you you're under oath.
He acknowledged he had failed to seek help for Torrey, despite hearing and witnessing abuse. He admitted that he was scared and overwhelmed at the time and expressed deep remorse, telling the court he still thought of Torrey daily and regretted not calling for help sooner.
On January 14th, 2021, around 2:15 rather, this defendant called 911 and stated, quote, "We have an emergency. Our daughter, she's unresponsive. She drank a lot of water. We tried to do CPR to get it out. Our 3-year-old daughter is choking on water right now." Police responded to 515 Selwood Circle within Greenville County and found 3-year-old Victoria Rose Smith unresponsive and badly injured. Co-defendant Ariel Robinson told first responders that they thought Tori was drinking too much water, but firefighters saw unexplained excessive bruising all over Tori's body. Deep purple bruising on her abdomen, bruising on her ear, bruising down her back, and up and down both of her legs. Police talked with Ariel Robinson, who gave an account of Tori's day on January 13, 2021, and the events leading up to when this defendant called 911. She told police that the night before, Tori had thrown up on the way to church. Ariel Robinson said after church, they ate pizza at home and Tori seemed fine. They went to bed with no issues, she said. The next morning, on January 14, 2021, Ariel said Tori woke up, ate pancakes while she and this defendant were home alone with the child, and the other 4 children were at school. Ariel Robinson said Tori kept asking for water, and this defendant filled up her cup 5 or 6 times. She also said Tori said her stomach hurt and that she was cold. She gave her a heated blanket and was holding Tori when Ariel Robinson said the child went limp. Ariel Robinson then said she tried to perform the Heimlich maneuver because she thought the child was choking. While police were on the scene, this defendant maintained Ariel Robinson's account of what happened to Tori. We took CPR training. She was pressing on her stomach, end quote. Investigator McGall asked this defendant, do you feel like her airway was blocked? This defendant said, I'm not sure. I was too busy trying to get paramedics here. She first thought she was choking. She tried to do the Heimlich. Investigators asked Ariel Robinson, judge, about the bruising on Tori's abdomen and whether it was there prior to EMS getting there. She said, I did that. She said, I was pushing really hard. Then an officer asked about the extensive bruising on Victoria's body. That's when Ariel Robinson blamed Tori's 7-year-old brother for the other bruising up and down her legs. She said he had anger issues. The officer further asked what a 7-year-old could do to cause such extreme bruising to the child's legs, and co-defendant Ariel Robinson said he'll pick up anything and hit her. Tori died, judge, later that day. An autopsy was conducted by Chief Medical Examiner Dr. Michael Ward, and he determined that Tori died from multiple force trauma, and the manner of death was homicide. In Dr. Ward's terms, she bled out inside her own legs. Several days later, they were both arrested. After the arrest, Austin Robinson's attorney, Lucas Marchant, who's present in court, contacted the state and stated that his client wished to make a statement. No promises were given to this defendant, and the phone call was on this defendant's accord. The defendant came in voluntarily and met with police to tell what had really happened to Tori. He said he had not physically ever hurt Tori, but that his wife would spit and beat her. Austin Robinson said Ariel Robinson hit Tori with different things, including a belt, paddle, flip-flop, hand, or whatever. He said Tori got the worst of it for some reason when Ariel would become angry over eating habits, such as Tori taking too long. He told police how Ariel had become angry the night before Tori's death because she threw up on herself on the way to church. The next morning, this defendant said it all started when Ariel was fussing at Tori for not eating her pancakes fast enough, and that Ariel had put Tori on a timer. This defendant said he heard Ariel beat Tori with a belt from outside the house and he could hear Tori crying. This defendant came inside and saw Ariel Robinson standing over Tori with a belt saying, "You're not done. You don't get to tell me when you're done." When he saw how badly Tori was beaten, he told Ariel, "Look at her. You've done too much. You've gone too far. You went too far this time." Ariel then put Tori in an Epsom salt bath. This defendant went off to CVS to buy medication to bring down the bruising, judge. This was at 1:00 p.m. 911 was not contacted until around 2:15 p.m. Law enforcement secured video from the CVS showing Austin Robinson, in fact, buying that liquid Tylenol that he talked about around 1:00 in his statement to police. Law enforcement also secured video from the church where the Robinsons attended church the night before Tori's death. The video at one point shows Tori being walked out of the church by Ariel Robinson wearing what appears to be nothing but a diaper and some undergarment, judge. And in the video, you see no visible injuries to the child's back, her legs, or her body at this time. The child did not have any known health problems, did not attend school, and at the time of Tori's death, the Robinsons were fostering to adopt Tori and her 2 brothers. Judge, the state has...
Ariel Robinson stood trial in May 2022. Prosecutors presented evidence that she had repeatedly Tori with a belt, leading to internal injuries that caused her death. Witnesses, including medical experts, testified to the severity of the trauma. After just 90 minutes of jury deliberation, Ariel was found guilty.
I think the medical testimony in this case was incredibly heartbreaking, and for folks who deal in the emergency room and who serve us in that way, and folks who deal with children in the most critical of situations, for them to say that this was substantially worse than anything they had seen, I think that has to put something into perspective for you. I can say that in my 13, 14 years of being a judge, I've never seen anything like this. I've never seen anything like this. Not even approaching it. And what compounds it is that I understand what your attorney is saying. Perhaps you snapped at that moment, but then why let this suffer and not get her medical attention that she desperately needed as she lay dying in her own bedroom? Based upon all that, the sentence of the court cannot be anything but life in prison. Thank you. When will we?
Judge Letitia Verdon remarked that the evidence was among the most disturbing she had encountered in her career and sentenced Ariel to life in prison. In June 2022, Jerry Robinson faced sentencing. During the hearing, he tearfully apologized to Tori's biological family and begged the judge for mercy.
Thank you, Your Honor, for allowing me to speak today. I would just like to give some context as to who I am as a person in my life. As you know, my full name is Jerry Austin Robinson II. I am the miracle child, and I say miracle because after years and years of my parents trying, they finally got me when they didn't think they would be able to have any child. But I'm the miracle child of Jerry and Linda Robinson. I'm 35 years old, and I was born on December 29th, 1986. My parents did the best to make sure I had the best life growing up, and I did my best to provide that same life for my kids from birth to even now. I'm a great father in person. I would give my last piece of clothing to anyone that needed it, and my last dollar out of my pocket if they needed that too. Your Honor, I've said all that to say this. I know this situation is hard and tough, and not a day goes by where I don't still think about Tori. There's nothing I wouldn't do to go back and change things, even though I know I can't. I loved her, and I still do. I wish I would have handled things differently and caught sooner, but I was terrified and scared. I didn't think that things were at that magnitude that they were until it was too late. And I have to live with that, and do live with that every day of my life. To Tori's family, I'm truly, truly sorry.
Turn around.
Sorry.
Keep your comments to me. I appreciate it.
Sorry.
Okay.
To Tori's family, I am truly, truly sorry for all of this. And I hope and pray that one day y'all can forgive me. To my family, I love y'all. Through 10 and 11 years of my marriage, I barely saw y'all and didn't see y'all all at once or at the same time. Some I haven't seen for 12 plus years. Thank you for being my support system through all of this. Your Honor, I know you have to make a decision about my sentencing, but if I could say this, and for the better part of last year, my kids, Kyle and Amanda Robinson, didn't get to see me. Starting August 22nd, we started doing phone visitation, which was going well. Then as of November the 12th, we started having in-person visits twice a month, which have been great. They have gotten back used to seeing me and hugging me on a consistent basis. Please think about that when you're making your decision. I've been on house arrest for over a year with no incident. I haven't been in any trouble. I make my payments on time. I haven't been violated for anything. I worked a steady job up until the week I came to plead guilty. I was advancing at that job as well. I was able to provide for my boys still during that past year of work. And I have a job that's wanting me to come back to work right now. And I know the charge carries 10 to 20 years. But while you're thinking about that, could you please think about and consider leaving me on house arrest? Not just for me to work, but for the Kyle and Amon. They don't deserve to have both their parents behind bars, especially when they've gotten back used to being able to physically see me and physically touch me. Thank you for listening, Your Honor.
Despite his emotional plea, Judge Verdon imposed the maximum sentence of 20 years, citing his failure to act as a direct contribution to the girl's death. She reminded him that standing by silently while the girl suffers is no less damaging than the act itself. The case closed with both foster parents incarcerated. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.